Thank you, Mr. Chairman. Director Comey, we will begin this line of questioning, then we'll finish it the next round. FISA and other similar related counterterrorism programs have been described even this morning as vital, critical, and indispensable to our national security. And many of us on both sides of the aisle believe FISA and similar counterterrorism programs prevent terrorist attacks and save American lives. But FISA and other surveillance programs are intentionally designed to preserve the privacy of U.S. citizens. They are intentionally designed to ensure the information is collected and used only for legitimate national security and criminal investigative purposes. There are statutory safeguards. There are warrants based on probable cause. There is a FISA court that is involved. There are audits on the back end, and we think so highly of this material. It is a felony punishable by up to 10 years in federal prison to unlawfully disseminate it. All of this was done to make sure this information gathered remains protected as it relates to U.S. citizens. The way I view it, Director Comey, the American people have an agreement with their government. We are going to give you the tools to keep us safe, even if it infringes on our privacy some. We're going to give you the tools. And government in return promises to safeguard the privacy of U.S. citizens. And when that deal is broken, it jeopardizes American trust in these surveillance programs. So let me ask you, do you agree FISA is critical to our national security?
I do.
Do you agree programs like FISA were intentionally designed to safeguard the identity of U.S. persons?
Yes, there are other important elements of it, but that's the primary goal, I believe.
It wasn't an afterthought. It wasn't an accident. These are intentional safeguards that we put in place to protect U.S. citizens. Is that correct?
Correct.
Do you agree much of what is learned from these programs is classified or otherwise legally protected?
All FISA applications, review by the court, collection by us pursuant to our FISA authority is classified.
The dissemination of which is a felony punishable by up to 10 years in prison?
Sure, dissemination, unauthorized dissemination.
Unauthorized dissemination of classified or otherwise legally protected material punishable by a felony up to 10 years in federal prison.
Yep, yes, as it should be.
All right. In January of this year, the Washington Post reported, according to a senior U.S. government official, a named U.S. citizen, and I will not use the name, a named U.S. citizen, phoned the Russian ambassador several times on December the 29th. In February of this year, the Washington Post, nine current and former officials who were in senior positions at multiple agencies at the time of the call spoke on the condition of anonymity to discuss intelligence matters, and that officials began poring over intelligence reports, intercepted communications, and diplomatic cables. In February of this year, the New York Times reported a U.S. citizen, whose name I will not use, discusses sanctions with the Russian ambassador in a phone call, according to officials who have seen a transcript of the wire-tapped conversation. And again in February of this year, the New York Times reported on a phone call involving a U.S. citizen, including significant discussions of phone records, intercepted calls, intercepted communications, and reported the NSA captured calls and then asked the FBI to collect as much information as possible. My time is up, so I will say this for this round. I thought it was against the law to disseminate classified information. Is it?
Oh, yes. It Sure, it's a serious crime. I'm not going to comment on those particular articles because I don't want to, in any circumstance, compound a criminal act by confirming that it was classified information. But in general, yes, it's a serious crime, and it should be, for the reasons you said.
We'll take it back up next round, Mr. Chairman.
Thank you, Ms. Sewell. We'll go back to, I'll yield myself 15 minutes, and we'll go back to Mr. Gowdy.
Thank you, Mr. Chairman. Director Comey, you and I were discussing the felonious dissemination of classified material during the last round. Is there an exception in the law for current or former U.S. officials who request anonymity?
To release classified information?
Yes, sir.
No.
Is there an exception in the law for reporters who want to break a story?
Well, that's a harder question as to whether a reporter incurs criminal liability by publishing classified information, and one probably beyond my ken. I'm not as good a lawyer as Mr. Schiff said I used to be.
Well, I don't know about that, but the statute does use the word publish, doesn't it?
It does, but that's a question I know the Department of Justice has struggled with through administration after administration.
I know the department struggled with it, the Fourth Circuit struggled with it, lots of people have struggled with it, but you're not aware of an exception in the current dissemination of classified information statute that carves out an exception for reporters.
No, I'm not aware of anything carved out in the statute. I don't think a reporter has been prosecuted, certainly in my lifetime, though.
Well, there have been a lot of statutes at bar in this investigation for which no one's ever been prosecuted or convicted, and that does not keep people from discussing those statutes, namely the Logan Act. In theory, how would reporters know a U.S. citizen made a telephone call to an agent of foreign power?
How would they know legally?
Yes.
If it was declassified and then discussed in a judicial proceeding or a congressional hearing, something like that.
And assume none of those facts are at play, how would they know?
Someone told them who shouldn't have told them.
How would a reporter know about the existence of intercepted phone calls?
Well, same thing. In a legitimate way, through an appropriate proceeding where there's been declassification. In any other way, in an illegitimate way.
How would reporters know if a transcript existed of an intercepted communication?
Same answer. The only legitimate way would be through a proceeding, appropriate proceeding. The illegitimate way would be somebody told them who shouldn't have told them.
What does the term mask mean in the concept of FISA and other surveillance programs?
As Director Rogers explained, it's our practice, approved by the FISA court, of removing the names of U.S. persons to protect their privacy and their identity unless it hits certain exceptions. So masking means, as Mike Rogers said, I'll often see an intelligence report from NSA that will say U.S. person number 1, U.S. person number 2, U.S. person number 3, and there's no further identification on the document.
Admiral Rogers said there are 20 people within the NSA that are part of the unmasking process. How many people within the FBI are part of the unmasking process?
I don't know for sure as I sit here. Surely more, given the nature of the FBI's work. We come into contact with U.S. persons a whole lot more than the NSA does because we may be conducting, we only conduct our operations in the United States to collect electronic surveillance, to conduct electronic surveillance. So I can find out the exact number. I don't know it as I sit here.
Well, I think, Director Comey, given the fact that you and I agree this is critical, vital, indispensable, a similar program is coming up for reauthorization this fall with a pretty strong headwind right now. It would be nice to know the universe of people who have the power to unmask a U.S. citizen's name, because that might provide something of a roadmap to investigate who might have actually disseminated a masked U.S. citizen's name.
Sure, the number is relevant, but what I hope the American people will realize is the number is important, but the culture behind it is, in fact, more important. The training, the rigor, the discipline. We are obsessive about FISA and the FBI for reasons I hope make sense to this committee, but everything that's FISA has to be labeled in such a way to warn people, this is FISA. We treat this in a special way. So we can get you the number, but I want to assure you the culture of the FBI and the NSA around how we treat U.S. person information is obsessive, and I mean that in a good way.
Director Comey, I am not arguing with you, and I do agree the culture is important, but if there are 100 people who have the ability to unmask and the knowledge of a previously masked name, then that's 100 different potential sources of investigation. And the smaller the number is, the easier your investigation is. So the number is relevant. I concede the culture is relevant. NSA, FBI, what other U.S. government agencies have the authority to unmask a U.S. citizen's name?
Well, I think all agencies that collect information pursuant to FISA have what are called standard minimization procedures, which are approved by the FISA court that govern how they will treat U.S. person information. So I know the NSA does, I know the CIA does, obviously the FBI does. I don't know for sure beyond that.
How about the Department of how about Maine Justice?
I mean, Maine Justice, I think, does have standard minimization procedures.
All right, so that's 4. The NSA, FBI, CIA, Maine Justice. Does the White House have the authority to unmask a U.S. citizen's name?
I think other elements of the government that are consumers of our products can ask the collectors to unmask. The unmasking resides with those who collected the information. And so if Mike Rogers' folks collected something and they send it to me in a report and it says U.S. person number 1 and it's important for the FBI to know who that is, our request will go back to them. The White House can make similar requests of the FBI or of NSA, but they don't on their own collect, so they can't on their own unmask. I got that about right?
Yeah, that's correct.
I guess what I'm getting at, Director Comey, is you say it's vital, you say it's critical, you say it's indispensable. We both know it's a threat to the reauthorization of 702 later on this fall. And oh, by the way, it's also a felony punishable by up to 10 years. So how would you begin your investigation, assuming for the sake of argument that a U.S. citizen's name appeared in the Washington Post and the New York Times unlawfully? Where would you begin that investigation?
Well, I'm not going to talk about any particular investigation.
That's why I said in theory.
You would start by figuring out, so who are the suspects? Who touched the information that you've concluded ended up unlawfully in the newspaper, and start with that universe, and then use investigative tools and techniques to see if you can eliminate people or include people as more serious suspects.
Do you know whether Director Clapper knew the name of the U.S. citizen that appeared in the New York Times and Washington Post?
I can't say in this forum because, again, I don't want to confirm that there was classified information in the newspaper.
Would he have access to an unmasked name?
In some circumstances, sure. He was the Director of National Intelligence, but I'm not talking about the particular.
Would Director Brennan have access to an unmasked U.S. citizen's name?
In some circumstances, yes.
Would National Security Advisor Susan Rice have access to an unmasked U.S. citizen's name?
I think yes, in general, and any other national security advisor would, I think, as a matter of their ordinary course of their business.
Would former White House advisor Ben Rhodes have access to an unmasked U.S. citizen's name?